Welcome to the first episode in our second season of Justice Center Weekly, a half-hour podcast from the Justice Center for Constitutional Freedoms. I'm your host, Kevin Steele, and joining me today is lawyer Allison Pejovic. Allison is part of a Justice Center legal team that recently filed an application to the Supreme Court of Canada, asking them to review a lower court ruling in a case challenging the federal government's COVID-19 travel mandates. These limited the charter rights of Canadians to freely move around the country based on vaccine status. The case was filed in February 2022 on behalf of a group of applicants, including, among others, former Newfoundland Premier Brian Peckford and the leader of the Federal People's Party of Canada, Maxime Bernier. The government dropped the mandates in June 2022. Later, at the end of October, in the middle of that trial, the federal court ruled that the case was moot, essentially saying that because the mandates had been rescinded, no public interest could be served by finishing the trial and issuing a judgment. This despite the fact that the federal government had unequivocally stated when they dropped the travel bans that they could be brought back at any time. And an appeal court upheld that mootness ruling, and so on to the Supreme Court, at least asking them to take up the case. Allison, your statement in the Justice Center press release on this file is what caught my eye. You said, quote, "The Supreme Court has an opportunity to create an important precedent for how Canadian courts deal with all so-called moot cases involving questions about the constitutionality of emergency orders," unquote. I take it from this that you see a much broader issue than just the travel mandate, obviously. We're testing the concept of mootness here. Is that not so?
Hi, Kevin. Thanks for having me today. Yes, so basically what we've been dealing with across Canada during these years of the COVID emergency were legal challenges to COVID orders, which were brought as quickly as possible, and many of them, unfortunately, were never heard because the governments at issue lifted the orders, whether they were vaccine passport, regulatory schemes, the travel mandates, lockdown orders, and a few of these cases were just never heard. And so citizens were wondering, what are my rights here? And what happened was the courts relied on what's called the doctrine of mootness, which comes from the Supreme Court of Canada's 1989 decision of Borowski. And that was a case where the Supreme Court of Canada set out a legal test to guide courts going forward when they're faced with a situation where as an example, the law at issue, which the parties were fighting about, no longer exists, whether it's repealed or in one case, a woman was denied an abortion and she brought an injunction to get an abortion. But before the case could be heard, she went and got the abortion. So the court found, there's no need for us to hear it. It's moot. And so there are certain parts of the legal test that the judges have to consider. We are actually challenging not whether the case was moot, as in whether there was a live controversy between the parties. We're challenging the discretionary part of that legal test. And that is the judges can make a finding as to whether the case should be heard. And that's based on their own discretion. Now, they've been given guidance by the Supreme Court of Canada. The three factors that they're supposed to consider are the existence of an adversarial context between the parties. The second part is what's known as judicial economy, and those are circumstances that warrant expenditure of limited judicial resources. And there are lots of parts of that aspect that I'll get into. And the last part of that analysis is whether the court is exercising its proper adjudicative role. It shouldn't intrude on the legislative sphere by making freestanding legislative-like pronouncements. And so with this Peckford and Bernier case, similarly to other cases that we've seen, the lower court exercised its discretion and said, I'm not going to hear this case. The public interest doesn't warrant it. The case is not evasive of review, which is a term used in Borowski, and, really just made these findings that this is not worth hearing. And so we're not arguing that mootness doesn't have a place, because certainly it has its usefulness. Courts are not going to hear every single case that comes before them where a law is being challenged that has been repealed, or someone's particular factual circumstances that were important to them at the time they brought a lawsuit are now gone. We don't want courts, courts are backed up as it is. They don't need to be making judicial pronouncements on every single issue that is no longer live. But here we have an unprecedented pandemic. The response has been unprecedented in Canada, the government's response. And so what we see here, and that we're hoping the Supreme Court of Canada will really agree with us on, is when the judges are exercising their discretion and trying to decide whether to hear a case, even though these orders have been lifted, is remembering that these orders themselves are not regular laws or regulations. They are made behind closed doors. They're made in secret. They're made without any opportunity for debate. So we've bypassed the whole parliamentary legislative process. There's no public consultation like there are with regular laws. Citizens have a chance to participate. That's a democratic process. Here, they're just made, month to month with no consultation, so that citizens really are really left out of this whole process. And the, parliament legislatures are also left out of the process. So this is just the whims of the executive making these decisions in an emergency. We're not here to say this wasn't an emergency. That's not what we're arguing in this particular case. But what we are saying is we need to take a better look at how emergency orders would fit into this legal test for mootness. And because these are not laws that have been debated, they really need to be given extra scrutiny, because if they're not, then there's no way for the governments to be held accountable. And so we really see it as a bigger issue, where there's a flaw in Borowski. It wasn't flawed when the case was originally decided, but now as we've moved forward in society, as we've got governments are now bringing in these harsh measures for emergency situations, the law has to evolve as well and respond to that. And we see that the Supreme Court has an opportunity here to expand upon that Borowski test and account for these special situations where, governments are making these orders very quickly without public consultation. And there has to be a way for governments to be held accountable. Because as we've seen in this travel mandate and the vaccine passport situation, these orders have been short-lived, but it doesn't mean that they didn't have significant consequences on citizens. And, we have people who weren't able to attend funerals because they couldn't fly across the country. People weren't allowed to enter, businesses, to go to the gym, to go to restaurants. People weren't allowed to go to church. So we really do need guidance from the Supreme Court as to when a judge is exercising discretion, should there be some extra considerations made for emergency situations and emergency orders? Because if not, you have Canadian citizens who are really left in the dark, wondering, what kind of country am I living in? Do I live in a country where it's completely lawful for the federal government to deny me the chance to leave? And for people who have remained unvaccinated, they've done so for a reason. And that's a scary thought. What kind of a country do I live in? They need to know whether or not they want to stay here. And that might be an extreme thing to say, but, I've talked to a lot of people, who have already left Canada because they were really afraid of being locked in the country. They left before this mandate came into force, or people who have family overseas who, might decide to leave permanently at the fear of not being able to see their families again. So these are real considerations that Canadians are thinking about. And to be left in limbo like this, to have the courts say, well, it's not in the public interest to have this decided because those mandates have been lifted. It's really quite shocking to us because we've never seen anything like this done in Canada, the scale of which, affects millions of citizens. When you have the court saying this is not in the public's interest to have this determined, that's what the federal court said in this case. The Federal Court of Appeal didn't find any fault in the lower court, finding that public interest was not so great as to have this case heard. But then you have the Manitoba Court of Appeal in the Gateway Bible case, who I would say got it right on their ruling on mootness. Of course, they ruled against the churches in Manitoba. That was the lockdown case. But there was a mootness challenge brought by the province of Manitoba before the appeal was even heard. And the Court of Appeal agreed with the churches and said, we really do need to guide the province because this could happen again, even though the lockdown is lifted. This is useful for us to make a decision here so that in the future, if this happens again, the government will know kind of what their boundaries are. And I think they got it right when you have, Manitoba Court of Appeal going one way, and then you have the Federal Court of Appeal in this case going another way. We need the Supreme Court of Canada to intervene and set some boundaries because the findings across the country have been wildly inconsistent. Another example is the vaccine passport case in Ontario that I went to Toronto to have this case heard in October of 2023. It was called Harji versus Ontario, and that was a case where our clients couldn't get into gyms, couldn't get into a wellness pool because they weren't vaccinated, couldn't go to restaurants. And so that was that there was a mirror case in BC called Cassian. Both challenging vaccine passport schemes in those respective provinces. The British Columbia Court of Appeal wanted to hear the case, even though the vaccine passport was lifted. So there's value in having this heard. It could be brought back. Ontario Court of Appeal went the other way. The Crown wasn't even challenging it on mootness, and the Ontario Court of Appeal, on its own accord, decided it didn't want to hear the case. Because it was moot and there wasn't enough value in having it heard. So, you've got citizens who are frustrated by these rulings, and these aren't insignificant issues. This doesn't affect just one person. This affects thousands to millions of people. And so I know my client, Premier Brian Peckford, is especially passionate about this issue, and rightly so, is that citizens need to know their rights. And especially in an emergency, they need to know whether the Charter actually protects them. They need to know the state of their country, and they need to be able to take that knowledge and decide to stay or decide to do something else. But when citizens are left in limbo, we can't function properly that way.
Okay. Now, in your statement that I quoted at the beginning, you talked about setting a precedent. I guess the obvious question is, did the Manitoba case not set any precedent at all, or was there no guidance for the courts from that because they're going the other way?
Well, it set a precedent for Manitoba, and a good one at that, and that precedent is persuasive on other provinces. But we raised the findings from that case when we were standing before the Ontario Court of Appeal in Harji, that the Manitoba Court of Appeal found that not hearing that lockdown appeal would be evasive of review, that the government's orders would be evasive of review. We also presented the Cassian case out of BC, and that court found that not hearing the vaccine passport case would be, the government's orders would be evasive of review, and the Ontario Court of Appeal went the other way. So
evasive of review. So maybe you could just explain that.
Yeah, sure. So the Supreme Court of Canada in Borowski, in its discussion of what does judicial economy mean when the court has to consider whether judicial resources are well spent in hearing a case when the law has been, repealed or an order has been lifted. And the court considers something called evasiveness of review. Would that law be evasive of review or not? And that phrase has been interpreted slightly differently depending on which court has written a decision. The Federal Court of Appeal in this Peckford case found that the evasiveness of review would be tied to whether or not there was a possibility that these vaccine mandates, travel mandates, could come back. And oddly, the federal government, it was in evidence, actually admitted that it wouldn't hesitate to bring back the travel mandates. And the Manitoba Court of Appeal looked at it a little differently and found that these lockdown orders would be evasive of review because they were short and because the government needed to know whether it acted lawfully so that it could take that guidance from the Court of Appeal into account when and if a similar situation arose in the future. So that phrase has been interpreted slightly differently depending on what court has heard the matter. And the lower court in the Peckford case actually tied evasiveness of review to whether there was an uncertainty in the law. And she found that because there have been other COVID cases across the country, the charter jurisprudence, the charter law is settled. And of course, we took issue with that because there have been no cases that across the country that have considered whether it was against Section 6 mobility rights under the charter to prohibit Canadians from leaving the country or from flying across the country. There has been no case ever considered or decided in this country with respect to the issue of whether the Minister of Transport could lawfully, under the Aeronautics Act, make public health orders. And that is a situation that could easily arise in the future, regardless of whether it's COVID again or the COVID vaccine. It could be any pandemic or any medication. Does he have the authority under that legislation to make a public health order? That is a very important issue that in our view should have been determined, because that has value going forward, regardless of again, whether it's COVID or something else. And another issue unique to our client, Maxime Bernier, is, of course, he's someone who needs to fly across the country to grow his political party. And he was arguing that this was a violation of his democratic rights under Section 3 of the Charter. He was also arguing that this was a violation of the Elections Act, because when in history has a Canadian political opponent been able to put into effect a law or legal measure which prohibited another political candidate from basically growing their party or campaigning across the country? That is the antithesis of democracy. So, those issues were novel. They had never been decided before. And yet the federal court and the Federal Court of Appeal found that there's not enough public interest to have those issues decided. And, before we get to the merits of our appeal, should we get there, we just want the Supreme Court of Canada to really consider the fact that we're in a very unique circumstance here with these emergency orders. And these orders are not they don't have an insignificant effect on Canadians' rights. We've never seen anything like a lockdown before. We've never seen anything like a vaccine passport regime before. These are measures you would expect to see in far off places and under communist regimes, and they were on our doorstep for years in this country. And there's immense value for Canadians, whether they were vaccinated or not, to know whether this was lawful. And we focus on the unvaccinated. They were the minority in Canada. So there were still millions of them who couldn't get on airplanes. But there's also the vaccinated. There are many vaccinated people who only took the vaccines because they wanted to travel. Sure, there were those who were lining up and couldn't wait to get them. But there were also a large percentage that, were really felt pressured by the federal government and felt like we want to go on a vacation. We need to get across the country for work. We need to see our families. We need to travel overseas for business or to see our, sick loved ones. Yeah, let's roll up our sleeve and get that shot. But maybe they wouldn't have done that had that pressure not been there. So there's a great interest for them too to know whether this was lawful. And so again, we find it quite shocking that the courts have not been interested enough in having this very, very important legal issue determined.
Okay, well, I noticed that you'd concentrated on the fact that these are emergency orders. In other words, they come in fast and maybe they go fast, and that's what makes them evasive of review, if I understand the term. Does this have to apply to just emergency order, or would it apply to any sort of government edict that comes and goes so fast? And then on top of that, there is the problem with the delays in the court system, or the slowness of the court system compared to, the speed with governments can act. Does that factor in?
Yeah, and that's the thing. You want to have a conversation with the court if you have enough time to do so. Really get into the realities on the ground, and you're absolutely right. So these mandates came into effect at the end of November in 2021, and we filed our application for judicial review on February 1st, 2022, and we were in cross-examinations with, we had 5 expert witnesses, we had 6 client affidavits. The other side had multiple experts, multiple government witnesses. We were in cross-examinations for 6 weeks, morning till, early evening, day after day. It was a punishing schedule, but we got it done. There was the Crown, our clients, the other applicants in the case moved, we moved very well together to get it done. And the mandates were lifted in June as we were finishing the cross-examinations, and we had the hearing set for October of 2022. And we moved as fast as we could. The court, couldn't get us in any faster. And we still, after the cross-examinations were done, needed to have time to write our factum of law based on the evidence that came out of the cross-exams. So we really moved as fast as we could. But, there's this opportunity for governments to put in these emergency orders quickly without debate. And you have groups like ours who responded as quickly as we could and still are not able to get before the court before these mandates are lifted. And so this could happen over and over and over and over again. If that case wasn't heard in October 2022, if the mandate was brought back in December of 2022, the government could have done that. They could have done that because we'd already lost at the first round by then. And they said, without hesitation, we can just bring it back. If COVID reared its ugly head again, to the extent that they felt they had to bring it back, they could have brought it back. And we would have been, having to do this all over again. And what a waste of resources for all parties to bring in experts again, to have it determined again. And the courts say, well, that'd be a different point in the pandemic. And so you have to get different experts anyway. But I mean, we want a ruling, win or lose. Canadians want to know, as I've said, what is the state of our country? What is the state of our democracy? Can we as Canadians be prohibited from leaving our country because we haven't taken a novel medication that has multiple side effects and has caused death? And that is undisputed at this point. That was undisputed at the time that we filed our expert reports, but certainly now there have been deaths, there have been adverse effects, and this is critical for Canadians to know whether that government action is lawful.
Okay, one last question. This question is not to put you on the spot and predict an outcome. It's more to get an understanding of what you're asking for from the Supreme Court. What would a favorable ruling look like to you? Would they say, okay, you've got to go back and try these cases again, or would they just come out with general guidance going forward kind of thing? Are you looking for either of those or both of those?
Yeah, so I mean, you never know exactly what you're going to get with the Supreme Court of Canada, but what I would expect if they granted us leave to appeal, and so we don't know whether they want to hear the case. So first of all, we need a finding that they want to hear the case. And then if we put through this appeal, because the lower court never went through the charter analysis, never even heard the evidence, we can't ask the Supreme Court of Canada to hear the evidence at this point. What they would do, if we were successful, they would send it back down to the lower court to start over and have the case argued, as we plan to do in October of 2022. That's the best that we could get if we won. But at the same, so that's a factual finding, was that this case should go back down. But also they would provide, most likely, guidance if they accepted that the issues that, as we frame them, are nationally important. We would hope that they would give guidance to the courts, as I've set out, that when we are in a situation of a pandemic or whatever kind of emergency, and I can foresee this might come down the line with all the discussions about climate change and, who knows what's going to come in the future, but I can see that being something that we might be faced with in the future. But whatever emergency we're facing, when governments put in these harsh charter infringing measures, even though they're short-lived, which have significant consequences on the population, is there to be more intense scrutiny upon the governments in those situations? And when the judges are exercising their discretion and deciding whether to hear those cases, are there additional factors? What are those factors? So we're looking for, the Supreme Court is good at setting out guidance in terms of, whether it's bullet points or, separate lists of factors, a legal test. We're not asking for the Borowski test to be thrown out the window. We're asking for it to be updated to reflect the current legal landscape and the current social landscape that we're facing in this country, that we can't ignore. We can't ignore what just happened these last 3 years, and to have courts, shut the door in Canadians' faces and say, we're not interested in hearing about these issues and making a decision on these issues. We say that's not acceptable. We need to have a set criteria, and the courts do too. They need to know, should we be putting extra scrutiny on governments? How important is this to hold governments accountable? And when there's a lack of transparency in the lawmaking process, as there are with these emergency orders, does that mean that, does that weigh in the balance of exercising discretion? Does that weigh in the favor of having the case heard? And another element that we raised was, what is the public interest? In the Borowski test, the definition of public interest is kind of vague. It talks about, is there a greater social cost to having a case left hanging, to have these legal issues left hanging, or should we have the case adjudicated? What's the social cost if we don't? And so, that's pretty vague. Courts have interpreted that differently. And, we're arguing here that when you have millions of Canadians affected, shouldn't the number of people affected in Canada have any bearing? Because if we can't even get past that hurdle, when millions of Canadians are prohibited from leaving the country and that's not in the public interest, then what is? The bar has been set so high. Is that right? Or did the Federal Court of Appeal get that wrong? So we need more of a clarification on what is the public interest. And if there's no public interest in having these issues heard, we say that these courts are getting that wrong, because the public is dying to know whether this was lawful. Even those who were pro lockdown, if all the lockdowns were lawful, they'd like to know that too. Everybody needs to know what the state of the charter is, whether the charter actually protects people. Canadians need to know that. They need to know whether they want to move their families here from overseas or whether they want to move to be where their families are. But just having this in limbo and having the government able to just lift the mandates before the cases are heard, that doesn't serve anybody. And it certainly doesn't serve judicial economy, and it certainly is a waste of the parties' resources, and it's a waste of court resources to force us to come before the court over and over and over again every time there's a new lockdown, when we could have those valuable precedents in place that will guide government behavior going forward, as the Manitoba Court of Appeal, we say, correctly found in their decision on mootness.
Right. Well, it sounds like a no-brainer to me. However, I guess I would consider partisan in this. Well, thanks, Allison, so much for laying it out for us, and we look forward to hearing back from the Supreme Court on this issue. And thanks for participating in this first episode of this second season of Justice Center Weekly. I hope to talk to you again real soon.
Thanks, Kevin, so much. Take care.